afternoon, Your Honors. May it please the Court, my name is Angela Lawson. I'm from the Memphis Bar, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes. All right, you may proceed.
All right, I'm here today on behalf of the appellant, Marion Osborne, in her individual capacity and in her capacity as the trustee of the trust. This case turns on the interpretation of that trust instrument and how the assets flow through that trust. Carl and Osborne and Marion, they married in 2021, and it was a brief marriage, and he died only 4 months later. But before he died, Mr. Osborne amended and restated his trust instrument to provide for his wife. And the appellees are going to try to make you think that the length of this marriage should have some bearing on your decision, but nobody's disputed the fact that this was a loving marriage and Mr. Osborne cared for his wife. The two major assets of this trust, and the ones around which this dispute have arisen, are the piece of real estate and some stock proceeds. The appellees are going to argue that they are vested in certain remainder interests in these assets. Well, I'm going to show you that the trust is the holder of those remainder interests. The appellee's argument's flawed when you examine first what happens when you carve out a remainder interest of a piece of property, or you carve out, the life estate. And then second, when you have to look at the trust step by step, article by article, to ascertain what the intent of Mr. Osborne was.
Let me ask you a procedural question on the front end. It's my understanding the trial court just looked at the documents and made a determination. Was there any live testimony ever presented?
No, Your Honor, it was just an argument. There was just a legal argument. There were no witnesses or anything like that at the hearing.
So basically the trial court just ruled on the pleadings and on the documents that were presented. Is
Yes,
that
Your Honor.
correct? Are there any material disputes of fact or any disputes of fact that the court needs to be made aware of?
I don't believe there's any dispute of fact. The issue is how the probate court interpreted the trust and which assets were assigned.
I understand the issue. I'm just trying to make sure what the trial court had before it to consider.
No, Your Honor, I don't believe there's any issues of fact. I think it really falls on the interpretation of the document.
Well, there's an issue that's been raised about, I believe, a former attorney wanting to present his...
Mr. Bradley.
Yes, whether the probate court erred in the exclusion of testimony from the drafter of the trust, Anthony Bradley.
Yes, Your Honor. That issue is in the order that the probate court issued. The judge found that the document was not clear, and she mentioned that there were some ambiguities, but she never specifically said what type of ambiguities there were. And so our position was if the court believed that there were some ambiguities in that document, then the testimony of Mr. Bradley would have been helpful for the court in making her determination and her ruling as to what the intent of the testator was and how the assets were supposed to flow through that trust. And so...
Was an offer of proof made?
Yes, Your Honor.
In the record?
I believe so, Your Honor.
Where was that made?
Your Honor, I'm not positive. I'm sorry, I don't know the answer to that question.
We don't have a transcript, do we?
We do, the transcript is, but I don't know in the record off the top of my head where that would be.
So you think an offer of proof was made? I didn't see one when I looked at it.
Your Honor, I know that that we discussed Mr. Bradley's, the fact that she excluded his testimony, and I believe that we talked about what it was that he was going to testify to, but I don't recall, Your Honor. I'm sorry.
Okay. All right. Go ahead.
Your Honor, our position is that the trust instrument is clear and unambiguous, and so his testimony, I don't think that the court needed it, but if the court felt that they needed it because it was ambiguous, then that is why we thought that his testimony would have been helpful.
Counsel, under 601 here, we have repeated references to a life estate, though, with regard to the property. And how do we square an express indication that the wife's getting a life estate with your position that wife essentially takes everything here?
Yes, Your Honor, that is clear. 601 does carve out the life estate. So during her lifetime, he carves out that she is entitled to these life estates, the life estate in the real estate and in the income of the stock immediately. Those are hers that nobody can take away from her. But then the Mr. Osborne never addressed what happened to those remainder interests. And so when you look at Article 7, the marital trust, it includes all remaining trust assets. So it gave her the option to be able to access those remainder interests if she needed them, or if she wanted them, or if the trustee felt like that she needed them. And the trust says for any reason. And so while she had an immediate right to use the life estates, then she had the ability to access those remainder interests through the marital trust. And so, why Mr. Osborne drafted the trust that way, I couldn't tell you, because I didn't prepare that trust, and I probably would have done it differently. But when you start at the beginning of the trust and you read it sequentially, article by article, and you kind of flow through Article 6, at the bottom of Article 6, it says that let's see, where does it say this? Sorry, Your Honor. It says, any property not distributed under this or prior articles of this instrument will be distributed in the following articles. So then you have to examine, what is that trust property? What's remaining that is going to pass into the following articles?
Well, let me ask you this. So you have all the life estate language in Article 6.
Yes.
And then in Article 7, you've got the marital trust.
Yes.
And so if I'm following from your briefs and from your argument, if I'm following the logic that you're using here and what you're arguing should be the way that everything is divided, there's no real difference in what you're saying and what happened here and a fee simple. What would have been the difference to the wife if she had taken by fee simple versus if she had taken by this language here? Because I think the crux of your argument is that she gets it all. Why would there be all this other language in there?
Well, Your Honor, it's not that she takes it all. It's that she has the option to take it all. But if she doesn't, then whatever is left over will continue to pass through the remainder of the trust. So she might only take a portion of those stock proceeds if she needs them for her future use, or if she's in for her health care or whatever it is in the future that she might need them. So,
But she can take it all,
She
I guess is
can.
what I'm saying.
She
She
does.
can take it all.
She
She
does.
can have everything if she wants it.
yes, and that's what the trust instrument's clear, that she can have it for any reason. And he even gives her the power of appointment.
I guess what I'm saying then is, so why even go into all this stuff about a life estate? And if that was the intent of Mr. Osborne, and I know that you're arguing that the intent of this entire trust was to take care of his wife and to provide for her
Yes,
needs
Your Honor.
during the time of her life. But if she was going to have control over everything anyway, then why are we even talking about life estates? Why is it in here if it has no meaning?
I don't think it has no meaning, Your Honor. I think we do have to presuppose what his intent might have been when he created that way. But if you look at it, the life estates were something that she had the immediate right to use that nobody could take away from her. And the remainder interests were if she needed them or if she wanted them. So they weren't something that she just had control. And, part of I think that the confusion might be is that she's the trustee of the marital trust. So right now, it looks she has control of that. But she might not always be the trustee of the marital trust. If she becomes incapacitated for any reason, then there is a succession list of trustees that could step in and fill that role. So it gives you more separation when you think about it that way, that she had the life estate interests, and then the remainder interests are held in a trust controlled by this trustee. And so I think that there's some conflation of that ownership.
Well, either way, though, she can wipe out the remainder.
She could, Your Honor, but a lot of trusts are drafted this way to estate planning to provide for, you provide for the wife and she can have as much access to the principal as she like, and then if anything's remaining, then it would pass to the children. And so this isn't an uncommon estate planning technique. I think the language and the way it was drafted is I can see how it causes confusion, but when you stop and break it down and you go step by step, there's nowhere else for these remainder interests to go. They have to be owned by that trust because there's never any carve out of these remainder interests for them to pass later on. The Article 7 says that my trustee shall administer the unappointed, it says that my trustee shall hold and administer the remaining trust property in a separate trust as provided in this article. It says, if my wife does not survive me, then you look to Article 8. But you don't even get to Article 8 in those later distributions until you get through Article 7. And Article 7 is very clear that she has the right to take it all out, to take all of the assets. Even the last part of Article 7, 705, says that if my wife has not fully exercised her testamentary general power of appointment, or then they shall administer the unappointed balance or the remainder of the marital trust as provided in Article 8.
Counsel, can I ask you about Article 2 here with regard to the reference to the son who's being disinherited here?
Yes.
When we have the language, I dearly love my son, but I'm not providing a distribution for him in my trust because we previously had discussed and agreed to a transfer. How does that, so in lieu of a distribution from my trust, that language seems to suggest that what we have here is a circumstance where Mr. Osborne thought he was providing some kind of distribution to his children, grandchildren here. And how do we understand Article 2 fitting in as part of a comprehensive whole with your reading of how 6 and 7 interact?
All right. I think Article 2 is clear that his son he dealt with him outside of the trust and any of his other estate planning or assets that he had and beneficiaries and whatnot. I think that the fact that he did provide for his children in Articles 8 and 9, but he wanted to provide for his wife first. So it was whatever they got, whatever was left over. And so they're not disinherited. So they still have the right to take whatever is remaining at the end of Article 7. And so I think that the fact that she has the right to take it is one thing, but they're not disinherited. They have a contingent remainder interest, and that's the argument. That's the difference. And the Pelleys argue that they have this vested interest, but nowhere in the trust instrument does it show that they are vested in anything. Their interest is always contingent on what happens during Marion's lifetime. Even Articles 8, where you begin the distributions to the Pelleys, it all says after the death of my wife. So you can't even determine.
The marital trust is the holder of the contingent remainder, or is the holder at present of the contingent remainder in this case?
Well, not the contingent remainder. It's the marital trust is the holder of the vested remainder, and so that's the distinction between my argument and then the Pelleys, is that we believe that the marital trust has the vested interest in the remainder, and the Pelleys' interest is only contingent, and they won't know what assets are in those following articles until after the death of Marion.
And under your understanding of the trust, there's no duties of the trustee towards any future beneficiaries under 8 or 9, and the whole estate could be dissipated. Essentially, she could use every dollar here if she wanted.
Yes, Your Honor. When you read the clear language of Article 7, it gives her access to the entire principal. Either she can request it or the trustee can distribute it to her, and it even says specifically for any reason. And just when you read it all together as a whole, I think that's the only conclusion that you can get to. Thank you, Your Honors.
Good afternoon, Your Honors. May it please the Court, my name is Jonathan Ring. I represent the appellees, Leanne Kelly, who's a daughter of Mr. Osborne, Morgan Osborne, and Olivia Osborne, who are two of the granddaughters of Mr. Osborne in Mid-South Christian College, who is a charity located in Memphis. All of these individuals were named in Articles 8 and 9 of the trust as beneficiaries. And my clients are asking that the court affirm the probate court's decision. Our position is that the probate court correctly held that when you look at the trust as a whole, that Mr. Osborne clearly intended to carve out property for his children, his daughter, his grandchildren in Mid-South Christian College by the creation of the life estates. The life estates, which are found in 601, by a life estate's very definition, takes a splitting of an interest. You have the life estate with the life tenant, gets immediate access and enjoyment of the property with limitations. And then you have the remainder interest that's created. And the remainder interest is deferred until the death of the life tenant. We don't get the enjoyment of the remainder interest until the death of the life tenant. The life tenant is
Let me ask you
appellant.
this, and I don't mean to interrupt your introduction there, but your argument is that your clients have a vested remainder interest in this real estate. Is that correct?
My client's argument is that the trust holds it for their benefit.
Okay.
Again, we've got another splitting of duty of legal title and beneficial interest. Their beneficial interest doesn't really materialize until the death of the life tenant, but yes, that there's an interest there that should be protected and vested.
Let me ask you this then. Walk me through how they are entitled to that interest. Walk from the time of Mr. Osborne's death, walk me through the chain as far as where does it go to get to them?
Absolutely. So Articles 6, 7, and 8, and 9 deal with the trust property after Mr. Osborne's death. 601 states that the life estate for all income whatsoever to the appellant in the Epiphany cardio stock, okay, including any of the sales proceeds as well. Now, it's key there that the trustee is directed to have the right in his or her sole discretion to sell, invest, reinvest the sales proceeds of that stock. 601 tells us how the trustee is supposed to handle that. It stays there, it gives us the direction. The trustee can reinvest it, sell it, however they see fit. The income goes to the appellant, and so it tells us what happens to the remainder while the appellant is living. That paragraph goes on and states that my wife, the appellant, shall distribute to her a life estate and any real property used by her as her principal residence. And so right then, we have a splitting of interests. Okay, we have a splitting of the life estate that goes to the wife. There's no dispute of that. But we have the remainder interest, and by a very definition of remainder interest, the enjoyment of that remainder interest is postponed until the death of the life tenant. So the ability of the appellant as trustee, as beneficiary of the marital trust, and the probate court found that, and we agree with it, is that it stays in the Osborne trust as a whole. The remainder interest doesn't trickle down to the marital trust as appellant has alleged. And so that property stays there as well. And what governs a life estate and who's in control and what they're responsible to do for it is reflects back to Tennessee
How do you
law.
square that position with the very beginning language here of Article 7? If my wife survives me, my trustee shall hold and administer the remaining trust property in a separate trust as provided in this article. The trust will be referred to as the marital trust. And so you're saying it's not part of the marital trust, part of the Osborne trust. And how does that fit with the start of Article 7 there? I mean, isn't it remaining trust property?
I would say a couple of things. One, I've already talked about the splitting of the interest, and so our opinion is the split of the remainder interest while there's no beneficial right to it until the death of the life appellant. So by very definition of the life estate and remainder interest, there is no option for the marital trust to even use that. But also 605, which counsel referenced earlier, talks about any property not distributed under this or prior articles of this instrument will be distributed as provided in the following articles. It doesn't say in Article 7, it says following articles. So we would look to, okay, who's going to get this property post-death, which is in a following article, Article 8 and Article 9, to determine who the remainder interest is going to go to. Now again, there's no active distribution.
Is the remainder interest not, though, remaining trust property?
It is remaining trust property, but the life tenant and the trust has no rights to destroy that.
How do we square that with 702 and 704? And 702, my trustee shall distribute as much of the principal of the marital trust to my wife as she requests in writing. In addition, my trustee may distribute as much of the principal of the marital trust to my wife as my trustee determines necessary or advisable for any purpose. 704, my wife has a testamentary general power to appoint all or any portion of the principal and undistributed income remaining in the marital trust at her death among one or more persons or entities, including creditors. And how do we square, let's look at 702. How do we square 702 with your reading?
702, with our reading, is that there, again, the splitting of interest. If Mr. Osborne wanted his spouse, the appellant, to have all that property, to have the life estate, to have the remainder interest, don't put the life estate in there. And so the life estate is specifically defined and given, and then we get to the general language of Article 7. And so again, it doesn't even flow there, in our opinion. So if Article 6 01 wasn't in the trust, we wouldn't be here. If Article 6 said the remainder interest in these life estates goes to the marital trust to be used pursuant to those terms, we wouldn't be here. But it doesn't say that. And so I don't disagree with you that 702, 704 don't mesh with what our interpretation of what happens to the life estate property. It doesn't mesh with the interpretation that the probate court found, but that's because 702 and 704 don't apply to the life estate property. They're specifically carved out before the marital trust, before we even get to it. And so the rules of construction would also support that. The rules of construction in Tennessee, which are guidelines by which the probate court looked at, the guidelines by which this court are required to look at, takes the trust as a whole. It tells us that when reading the trust, we don't look at a specific section and eliminate the rest of it. That every word and clause is to be given meaning. No word or clause is to be rejected. And if there's two potential constructions, the one that disregards a word or clause should be rejected, and the one construction that gives effect to the will as a whole must be adopted.
Let me ask you this. Let me ask you a question. So then, if I'm understanding your argument, the remainder interest, you're arguing, go from Article 6 and skip Article 7. Article 7 never receives that remainder interest, Article 7 being the marital trust. Your argument is that the marital trust never receives the remainder of those life estates that have previously been given.
I don't think it skips. I think it stays in Article 6, because Article 6 tells us what the trustee can do with the Epiphany cardio stock.
Well, okay, so
So-
if it stays in Article 6, it doesn't become part of the marital property, then where do we go next from Article 6? Like I asked you before to lead me through the process, where do we look next then to say, well, who owns these remainder interests? Who's entitled to them? Where are they?
It would not have been an issue until the appellant sought to sell the house in Germantown.
Right.
And so once she did, it became an issue. So if that house had been kept as a house, it would not have been an issue. And so the Epiphany cardio stock wouldn't have been an issue. It wouldn't have even come up from the perspective of my clients until that happened. And so it stays with the trust. The appellant is trustee of the Osborne Trust. She's also trustee of the marital trust, but she holds the legal title to that. She doesn't get the beneficial interest to it, but she holds the legal title to it. It stays in 6 and waits until the life tenant dies. So it doesn't skip over to 8 and 9. Now, when we have the termination, the early termination of a life tenant's interest because of sale, then we look to who is supposed to get this property at the death of the life tenant, and that is via my clients, via 8 and 9. Okay. So, in discussing the rules of construction, referring back to the two potential constructions, what we have here is two potential constructions. The appellant's construction would take place if 601 is ignored, if you just remove those paragraphs. So it's a interpretation that would be able to be reached by totally ignoring 601. Our interpretation gives full meaning to 601, it gives full meaning to Article 7, the marital trust, gives full meaning to Article 8, gives full meaning to Article 9.
Necessarily ignoring, and is the structure that's being created here essentially one in which Mr. Osborne's provided, she has a life estate, I'm putting the rest of it in this marital trust, and if she doesn't use it, then this is how I want it divided up, rather than it going to her with sort of no directive of how it's divided up if she doesn't make use of all of the property during her lifetime. I mean, doesn't that bring some continuity, that understanding of it?
When you say the rest of it, everything but the remainder interest, yes. So any other cash, any other stock other than the Epiphany stock, any other real property other than the Germantown house and the Wharf condo, yes. That all goes to the marital trust. The appellant, as trustee, gets all the income for that. Again, the non-life estate property, the non-remainder interest, yes, absolutely.
I've asked this before, I want to try this again and see if I can get, I'm a little slow on this point. If my wife survives me, my trustee shall hold and administer the remaining trust property in a separate trust. Why is the remainder not remaining trust property?
Because the enjoyment of the remainder is postponed until the death of the life tenant. The trust interpretation found by the probate court, the trust interpretation that my clients have set forth, which was adopted by the probate court, again, gives meaning to all of the terms of the trust. Again, if Mr. Osborne wanted for his spouse, the appellant, to have full control, as the appellant has alleged, just eliminate 601. Why put those specific provisions in there if you're not going to give them the full meaning? Again, if the trust had been drafted differently and it said the remainder interests go to the marital trust to be used by my wife if she desires, or some other manner, we wouldn't be here. But it doesn't say that. And so that's why, again, we're asking that the court affirm the probate court's ruling, is that it complies not only with the definitions of the life estate and the remainder interest, which are non-concurrent interests that are postponed until the death of the life tenant, but it also comports with the full reading of the trust and provides for both sets of beneficiaries, which is clearly the intent of Mr. Osborne based on a full reading of the trust. I have some additional time, but I've concluded, and I'm happy to address Mr. Bradley's testimony, but if there's questions on the interpretation of the trust, I'll answer those.
Anything you want to address about, was an offer of proof made?
No offer of proof was made to my knowledge. Mr. Bradley's deposition was taken, and
Was his deposition marked as an exhibit or
it was
introduced?
not. It was not presented to the trial court. It wasn't offered to the trial court. Before the trial, I filed a motion in limine to exclude Mr. Bradley's testimony because the case, and the case law supports this, several cases I've cited, including McBride v. Summerall, but basically that we look at the four corners of the document for interpretation. If there's an ambiguity, it has to be a latent ambiguity for outside information to come in, and there wasn't a latent ambiguity in this trust. Again, so the court excluded it, properly excluded it, and we would hold that, the McBride case, which is a will construction case, surprisingly enough, it's a will construction case where there's no named remainder interest for a spouse's life estate. The court held there that, it's a Court of Appeals case, it held that we don't look outside the four corners of the document to reconcile that. We don't get to pick and choose other information regarding what would come in and describe. The testator in that document and Mr. Osborne in his trust document speaks through the four corners of his document, not what someone else says he's supposed to intended to do at that point. So, Your Honor, I ask that the court affirm the probate court's ruling on both those issues. Thank you.
Thank you.
I just wanted to address a couple of things that that were brought up in the appellee's argument and the question that you had, Your Honor, about the death of the life tenant and the rules of construction. I think that the issue is who owns the remainder interest. And, the appellee said that you have to wait until the death of the life tenant to know who is the owner or, where that trust, to enjoy that benefit. But all the time during Marion, the wife, she owned the life estate interest, and the trust always held the remainder interest. So when she passes away, when the wife dies, that interest is still owned by the trust. And then you have to look to the trust to figure out where that interest goes. The argument that the appellee makes.
Let me ask you this.
Yes.
When you say the trust, you're referring to the marital trust?
Yes, Your Honor. Well, the trust as a whole, because when you have to, all of the assets are in the marital trust. And so the remainder interests are owned by the marital trust. And so
Your opposing counsel is arguing that the remainder interest never went into the marital trust. But your position is that everything went into the marital trust.
I think that's the only way you can read the beginning of Article 7 is that all of the remaining trust property is going to be held and administered in this marital trust. And so to carve out those remainder interests or to say that they're somehow held outside of that marital trust is adding to things to the trust and creating vested interests in the Articles 8 and 9 that you can't do without, following the rules of construction. The only way to give meaning to the beginning of Article 7 is to find that those remainder interests are owned by the trust. And when you get to Article 8, it's Article 8 and 9 are clear in that you can't look to those articles until the death of the spouse. So you're not going to know what is going to flow through Articles 8 and 9 until Marion passes away. It may be there, she might have, the remainder interest might still be there. She might have only used half of the proceeds of the stock. There might be, she might have taken it all, but we can't know that until she passes away. And so that's the position that we've taken, is that the only way to read this is that all of the interests, the remainder interests, everything that is remaining flows into the marital trust. And so we would ask, Your Honors, that you should reverse the probate court finding that the Pelleys were not vested in those interests and that those remainder interests were held by the marital trust. Thank you.
Thank you. Thank you, counsel. We appreciate your argument, your briefs. We'll take this matter under advisement and attempt to get you an opinion at the earliest possible time. I believe that concludes the call of the docket for this afternoon. We will stand in recess to the call of the docket by the presiding judge.